I was in Charles Reich's first constitutional law class. I was in his second property class. The first property class had apparently not gone so well. We first-year students were told, oh, Reich? Oh, too bad. But we all, in fact, fell in love with him promptly. He taught me a couple of things in that first-year class. One memorable line, lawyers are not hired guns, they're hired knife throwers. And then he taught me how to teach in an important way. I'm a colleague of Jillian's at Columbia Law School, where I've long taught administrative law. And what I realized when we got to the end of constitutional law and I studied for whatever was going to be on the exam was, wait a minute, this whole course was an elegantly constructed argument for Mr. Justice Black and the living Constitution and not Felix Frankfurter. It was a wonderful construction of argument. And he also taught me, I suppose, that it is fine to mystify students for a while, as long as every now and then you talk to them in ways that pierce through the fog. We would see him in the library every now and then after 2 or 3 classes, writing on yellow foolscap what would be his notes for the lectures, which were just extraordinary and fantastic. But there was, later on, there was the thrill as editor-in-chief of the Law Journal of editing the new property. And then I had the good luck, I suppose, to be given the task in the Solicitor General's office of writing the amicus brief in Goldberg versus Kelly. And so I'd like to think that the presence of the new property in the Supreme Court's opinion has something to do with our use of it in that amicus brief. The case was not about whether process was due, which is sometimes misunderstood. Both New York State and the federal government conceded that process was due. The whole argument was about, well, how much process was due? Did these welfare beneficiaries get enough process to satisfy the demands of the Due Process Clause? And that resulted in an opinion that said no, as you know, with a dissent from Justice Black, and then eventually a retrenchment in Matthews versus Eldridge. And I think what I want to say, by way of reacting to some of the other things that have been said. One, the new property has a continuity that hasn't been mentioned in my mind, which maybe was forced on me by another course I took while a student at Yale with Telford Taylor, who would later become my colleague at Columbia Law School. And he had us write about some case that had already been decided by the Supreme Court in his Supreme Court seminar, and I chose Green versus McElroy, which had been one of the cases during the McCarthy period. And what I think I learned during that exercise was that the Supreme Court's role during the McCarthy period was to bring procedure to bear against McCarthyism. And in the service of government employment or security clearances, the court had sort of failed to do that in Joint Anti-Fascists, but that was 4-4, and everyone understood that really it was the dissent in the DC Circuit that ought to prevail, and Frankfurter's dissent in Joint Anti-Fascist that ought to prevail. Frankfurter saw the Due Process Clause in a very different way from the way that Justice Brennan would see it, and perhaps that Charles Reich would see it. But nonetheless, there's a groundwork which is laid and which others in addition to Charles were seeing. My colleague Harry Jones, at about the same time as the new property was written, my colleague Harry Jones was writing a piece with very similar message to it that didn't attract quite the same public acclaim, but one could argue deserved it. But I want to say that in this instance, maybe Justice Frankfurter was closer to the truth about how you construct due process than either Justice Brennan, for whom I had the privilege of clerking, or Justice Powell. Either Goldberg or Mishaw or Matthews versus Eldridge. Jerry Mishaw criticized Goldberg quite severely and did it along the lines of Justice Black's dissent. You don't understand what the impact of this opinion will be, Justice Black wrote, was, Jerry Mishaw wrote, on the way in which welfare is administered. You're going to drive out the professionals who know something, who are in a position to exercise some discretion, and driving out the professionals turn the administration of welfare into a bureaucratic mess with hearings that won't mean all that much, but which result from failures of handling at the street level that result from taking away the professionals, and that's what happened. And Mishaw was also a severe critic of Matthews versus Eldridge, but with a vision of procedure, how one gets to appropriate procedure, that's quite different from anything that either Justice Brennan in Goldberg versus Kelly, this engineer's view, I think Mishaw called it, of the due process clause, or Justice Powell had in mind. For Jerry Mishaw, the problem of due process is that there are three ways of constructing it. One of them, the managerial way, which Gillian mentioned. One of them, the individual fairness way, which lived in the work of Frank Michelman as well as Justice Brennan. And one of them, if you like, the professional way, the way in which one relies on well-trained individuals who act with discretion. And what Mishaw said is all three of these are appropriate visions of fairness. And they're incompatible with one another. You can't move to one of them without giving up something from the others of them. So I'll just conclude with two other things. One is a recollection of Reich, who was writing The Greening of America while I was a student there, and we would have dinner with him. Not very many. Guido, I don't know if you ever took us to dinner at the Blessings, but probably once a month or more frequently, groups of students would trot out to the Blessings with Charles Reich and have a nice Chinese dinner. He was a wonderful friend to his students. The other thing is, well, he realized he didn't want to be a lawyer until this happened. And I just want to suggest that he has an inheritor today in the world, someone else who didn't want to be a lawyer until something else happened, which has contributed enormously to one's visions of justice, and that's Bryan Stevenson.